celebrate the partnership of the legal system which the community serves. We recognise the importance of the community in supporting the rule of law, in ensuring a fair and just society, for it's vital to that partnership that we understand how the rule of law underpins our successful, multicultural and democratic nation. And indeed, that's precisely the point that Chief Justice Alsop has been discussing. Well, my evolving concern as President of the Australian Human Rights Commission is that while the phrase the rule of law slips smoothly from our lips, few in the community have a clear idea of what it means. Few Australians understand our constitutional structure. Few Australians understand the principle of the separation of powers among the executive, legislature and judiciary. Even fewer Australians understand that this country is exceptional in its failure to include constitutional or legislative rights and freedoms as part of our national laws. Here in Victoria, of course, you have the Charter of Rights, and I think the community has a much stronger sense of the rule of law. Indeed, as we watched from Sydney in my case, but perhaps most of Australia, it was the Victorian community that reacted so swiftly to the proposed Operation Fortitude, under which Border Force officers were to stop and question Melburnians to establish their visa status. But for most Australians, the idea of the rule of law is abstract and hard to grasp. So let me give a human face to honour this principle. This is the story on the public record of a 22-year-old Aboriginal woman in Western Australia, Miss Du. About 2.5 years ago, she died in police custody in a cell in South Headland in the Pilbara region of Western Australia. The police had been called to Miss Du's home by her grandmother after Miss Du had allegedly been subject to domestic violence at the hands of her partner. When the police realised that Miss Du owed $3,000 in fines, parking, traffic, etc., she was arrested immediately and held in a police lockup. When she complained of pain from the violence she'd suffered, she was taken to a hospital where it is alleged the police said she was faking. The medical staff diagnosed her with behavioural issues and she was discharged from police custody. Again, she complained of illness and she was taken again to hospital, where she was returned again to her police cell without treatment. Finally, and for the third time, she was put into a police van to be taken to a medical centre, dying on the way from fractured ribs leading to septicemia and pneumonia. While after nearly 2.5 years we've yet to receive the coroner's report on this matter, Ms. Du's story is one of hundreds of often impoverished victims of domestic violence, imprisoned under an unfair fine system, some, as we've seen, dying in custody. What was the role of the rule of law in this tragedy? What of Ms. Du's common law rights to freedom from arbitrary detention, to legal advice, to protection from violence, to fair access to medical care? I suggest that our failure as a community to understand what the rule of law means in practical terms has allowed governments to assume unprecedented powers of executive discretion, to diminish and in some cases remove the judicial power of review, and to fail to provide fair access to justice for the most vulnerable. Ms. Du's case demonstrates how critical it is to protect the rights of those marginalised by society, for we all know the test of a just society is how it treats its most vulnerable. In practice, it often falls to community legal centres and legal aid organisations to ensure that the rule of law has meaning for the disadvantaged. Over the last few years, many of these bodies have seen continuing funding uncertainty and reduction. The Productivity Commission has reported that an extra $200 million in funding is required to meet the demands of legal assistance. Community legal centres are facing a 29% cut in comparable funding nationally, and we're seeing a drop of $42 million this year to $30 million over the following 2 years. We've long relied on the generosity of the legal profession, non-government organisations and the community itself to fill the gap in services, and this is where I see the ray of light in this tale of woe. Most particularly, the Australian Human Rights Commission relies to a very significant degree on the pro bono support of lawyers throughout the profession. As part of our statutory mandate, the Commission receives about 20,000 inquiries and 2,500 formal complaints every year. We're charged with monitoring compliance with the human rights treaties to which Australia is a party. While Australia has been a significant global player in creating the international human rights regime, from the time of Doc Evatt and the Universal Declaration of Human Rights in 1948, that Justice Bromberg has mentioned, up to the present. But we have not implemented these treaties, most particularly the International Covenant on Civil and Political Rights, or the Convention on the Rights of the Child, in our domestic law. Indeed, under recent amendments to the Migration Act, even references to the Refugee Convention have been repealed in favour of the Minister's discretion. The consequence of the failure to pass laws to give effect to international human rights law is that while we at the Commission, and I obviously as President, couch our advocacy in terms of that international law, our courts and government ministers are not able to be bound by them. Hampered by this curious and exceptional disconnect, we investigate and conciliate complaints of discrimination on the grounds of age, sex, race, disability, and complaints of breaches of human rights by the Commonwealth. And in addressing these complaints, the Commission provides individuals with a free, timely and cost-efficient means of resolving the dispute, achieving a conciliation rate of 72% last year. And in that way, I think that the Commission does manage, through Commission staff, thousands of Australians have a genuine opportunity to access to justice. And there are three matters that I'd like to raise very quickly with you that are of particular and growing concern to the Commission. The first is the disproportionate representation of Indigenous people in our prisons in Australia. Aboriginal and Torres Strait Islander adults are 15 times more likely to be in prison than non-Indigenous Australians. The juvenile detention rate for Aboriginal and Torres Strait Islanders is around 24 times the rate of non-Indigenous youth. The problem has not been helped by the introduction of the Northern Territory's paperless arrest powers, which for the most part were upheld by the High Court last year. Such powers in the Northern Territory have already significantly increased the detention of Aboriginal Australians. And the decision by the High Court illustrates the disconnect between Australian law and human rights law. In the absence of a Charter of Rights or constitutional protections, it's very difficult for the courts to call upon the common law to assess when arbitrary detention has taken place. Where the Northern Territory legislation is interpreted to be unambiguous, there is no room for the court to import the principle of the International Covenant on Civil and Political Rights against arbitrary, prolonged detention. Addressing these extraordinary rates and unacceptable rates of Indigenous detention requires significant reform, and my colleague, the Aboriginal and Social Justice Commissioner, Mick Gooder, argues for reinvestment in the community so that a proportion of the funds that would have been spent on imprisonment are diverted to community programs and strategies to respond to the underlying causes of Indigenous offending. These sorts of approaches are at least a positive effort to break the cycle of reoffending, which is now increasingly becoming part of an intergenerational problem. Yet for those already caught in the prison systems, it falls to the legal assistance providers to provide proper support, such as those that make up the Aboriginal and Torres Strait Islander legal services. Again, funding uncertainties for these organisations adversely affect the people most needing assistance. And I greatly commend the work of the Aboriginal legal services, and I think the opening of this legal year for the community is an opportunity for us to reflect on their work and to understand the need for providing better services. The second area of concern I wanted to raise is what appears to be a rise of so-called administrative detention, particularly for those with cognitive disabilities. We receive and have received over many years complaints from the community of people who, with cognitive disabilities, plead unfit to stand trial or are found not guilty by reason of insanity, and are then held for extraordinary lengths of time without proper regulatory review. Very recently, we found that 4 men with intellectual and cognitive disabilities have been held in maximum security facilities in Australia, and this is true in all jurisdictions, or most jurisdictions in Australia, with, I might add, a particular exception, Victoria. But each complainant was found unfit to stand trial, or not guilty by reason of insanity. But had they pleaded guilty, they would have had a maximum sentence of 12 months. Instead, they were imprisoned respectively for 4.5 years and 6 years. And in the past, we've had people held for 10 or 12 years from some jurisdictions in Australia without any legal review or legal advice. Funding concerns are typically given as the reason why it's necessary to hold people in prison facilities rather than in proper medical facilities, but I no longer believe this is an adequate response, and it is certainly a breach of the International Convention on the rights of those with disabilities. But the last matter I wanted to raise concerns the right of judicial review for asylum seekers. Recent migration laws diminish the legal rights of asylum seekers and refugees. And we've seen in the past few years, and certainly even in the last year or so, increasingly clear rules amending the Migration Act, increasing executive discretion for the Minister, and limiting rights to judicial review. There are currently an estimated 30,000 asylum seekers in the Australian community on bridging visas, and about 2,000 of them still in detention in Australia, another 1,500 in Manus and Nauru, waiting for their applications to be processed. The fast-track process adopted by the government means that many of these people will have a limited form of merits review and will be subject to new legal tests to meet our definition of refugee status, a definition, I might add, that is one of national law, not of international law. Some of you may have seen the application forms. They are many, many pages long. They're exceptionally hard to complete, especially to those from culturally and linguistically diverse backgrounds. Almost needless to observe, where most will not have legal representation or advice throughout this process. Where an application is refused, and I believe the system is designed to ensure a high rate of rejection, many will apply for judicial review. And I'm pleased to say that yet again the legal profession and the wider community have risen to the challenge. A refugee justice network is now being formed to develop and train a group of barristers and solicitors willing to provide pro bono assistance to asylum seekers applying for judicial review. And we expect at least hundreds of these to become necessary by about April or May this year. And I want to commend the efforts of Justice Connect and RACS, the Refugee Advice and Casework Service, who are developing this network. Their work will play a very large part in ensuring whether these asylum seekers receive proper access to our legal system and to a determination of their status according to the rule of law. So in conclusion, I can only repeat what has been axiomatic throughout my legal career, starting, as Justice Brumberg has said, at the University of Melbourne, and that is that we must exercise constant vigilance to ensure that the rule of law is respected and understood in Australia. And I'm particularly keen to see, through public education, a greater emphasis on the rule of law and the meaning of that rule of law in our democracy, and an understanding of our constitution and legislative system. But above all, and I think this point has been made again by Justice also, but above all, it's the community that promotes and protects our national commitment to fairness and justice. Perhaps the phrase "a fair go" illustrates what we mean, but it's far too general a term to really drill down to what we actually mean by the rule of law. I really commend the work of our community legal services. Absolutely delighted to see our young people picking up issues of this kind and speaking with such clarity. I wish all those within the community a successful engagement with the law and an engagement to have a fruitful year in 2016. Thank you all very much.